$500. If bail is posted, there will also be the following conditions that are ordered. Number one, there will need to be a waiver of extradition signed from any and all jurisdictions to be brought back here before the court. Number two, I'm going to require that Ms. Daybell not leave Bonneville, Jefferson, Madison, and Fremont counties. If she were to leave any of those counties while this case is pending without permission or authorization from the court, that would be a violation of the terms of bond and release. I'm also going to order that there be an ankle monitor that is placed on the defendant. That will need to be all lined out before she's eligible to bail out. It will be monitoring 24 hours a day, 7 days a week as to where the defendant is. And then lastly, I'm going to order as a term of any release or bail that the defendant appear for all court appearances, that she maintain contact with her counsel, and that she abide by all the laws of this state. We're going to go on the record on the telephone. Do I have Mr. Means and Mr. Webb?
Correct, Your Honor. Mr. Means. Yes, sir. Brian Webb.
All right, we're going to go on the record here. This is case number CR 3320-302, State of Idaho versus Lori Vallow, aka Lori Daybell. This matter is set for a hearing based upon the motion that was filed 2 days ago to disqualify me as the judge presiding over the case. The stipulation that has been filed, and under subsection A11, I think the court does have jurisdiction to rule on the issue of the continuance, and so I am going to sign the proposed order, and the preliminary hearing will be rescheduled to May 7th and 8th at 9 a.m. pursuant to the stipulation, as well as pursuant to the waiver of speedy prelim that has been signed, filed with the court by Ms. Daybell. Let's move now to the issue at hand, and that is the issue under Rule 25 that was filed to disqualify me as the magistrate. The court has taken considerable time in listening to the argument of both the state as well as the defense. The court has reviewed Rule 25 and has reviewed any case law relevant to Rule 25. In analyzing the motion, and I guess in summary, the motion to disqualify a judge is a right that every defendant has. There are rules relating to the motion to disqualify a judge without cause. There are time limits and there are time constraints, but so long as those are followed, every defendant has a right to disqualify at least one judge without cause, without reason, just because. The objection that was filed by Mr. Wood pertains to Rule 25A2 that outlines those time constraints. Specifically, Rule 25 designates, in all criminal actions except actions before drug courts or mental health courts, the parties each have the right to one disqualification without cause of the judge. Under subsection A2, it designates that a motion for disqualification without cause must be filed within 7 days after service of a written notice setting the action for status conference, pretrial conference, trial, or for hearing on the first contested motion, or within 14 days after the service of a written notice specifying who the presiding judge or magistrate to the action will be, whichever occurs first. And then the last sentence designates the motion must be filed before the commencement of a status conference, a pretrial conference, or contested proceeding or trial in the action. The court notes that the last sentence designates a contested proceeding, whereas earlier in the rule it says hearing on a first contested motion. There are many different ways to analyze this, but ultimately that last sentence is what is most relevant in my decision. And really what's relevant here is has there been a contested proceeding in this action? And if there has been, the time for filing has already expired. So I'm going to analyze the contested proceeding. The court reviewed Black's Law Dictionary, the court reviewed any case law, the court reviewed all of the rules and the statutes. There's no great definition for contested proceeding. In fact, there's a lot of indefinite definitions of what a contested proceeding is. The court notes that many times in criminal proceedings there are 5 or 6 criminal defendants that appear at the same time at a cattle call type situation where they have their initial appearance together. There is a public defender or defense attorney in the courtroom, and there's a prosecutor in the courtroom. During those initial appearances, as we had in this case, sometimes bond is brought up beforehand, sometimes it's brought up at the actual initial appearance, sometimes it's argued, sometimes it's stipulated to, sometimes there are other issues like agreeing on what day the preliminary hearing should be set, issues about how many witnesses can be there or what witnesses can be on which day. And those are sometimes contested. Those are rulings that the court makes based upon the argument. And a layperson looks at this and says, okay, contested proceeding means that there's disagreement. Both parties argue their own side and then the judge makes a ruling, which is precisely what happened last time. However, the legal definition or the rule definition of contested proceeding is perhaps a little bit different. I don't know if a contested proceeding is defined by something that is filed beforehand when the motion is filed. I don't know if it's something that indeed is just disagreed upon at a hearing that the judge makes a ruling on. But in the end, the definition of contested proceeding, I think, ultimately decides whether or not it was timely filed. There is a tendency, which is a very positive tendency, for the courts to err on the side of caution when it comes to defendants' rights. The court notes that under Rule 25, it is an absolute right for a defendant to disqualify a judge without cause. That right has to be followed pursuant to the rule, though. The problem that I have is that I don't have a definition of contested proceeding, and therefore I'm not going to rule whether or not it was, but at this time I am going to grant the motion to disqualify without cause, just because I don't have anything designating the definition of a contested proceeding, and I'm erring on the side of caution and on the side of defendants' rights to disqualify without cause. So with that will negate the need to hear further argument today on Mr. Means' motion on behalf of his client to disqualify me for cause. A new judge will be assigned to this case at the magistrate level. We'll set this for the preliminary hearing. I'm going to sign that order that continues the preliminary hearing for the 7th and the 8th. I don't believe there's anything else that we need to take up today. Mr. Wood, do you have any questions about my ruling here?
No, thank you, Your Honor.
Mr. Means, any questions about what I've ruled on here today?
No, Your Honor. I appreciate your effort.
Mr. Means, will you please prepare an order for the disqualification, or do we have a form, Madam Clerk?
I will prepare one.
Okay, it sounds like the clerk here is going to prepare that. And before that gets filed, I will sign the order for the continuance, and we'll go from there.
Great, Your Honor. Thank you.
Mr. Webb, any questions?
No, Judge. I don't have any questions. Thanks for asking.
All right. We will be in recess on this matter. Thank you.